Hi, and welcome to Quick Counsel with Kristen Lavoie and Aaron Van Kampen, where we provide you with an overview of a legal issue in just a few minutes. My name is Aaron, and today I'm going to be talking to you about challenging inventory searches. Inventory searches are an exception to the warrant requirement, and they're kind of a weird one because they don't require probable cause. That's because inventory searches are supposed to serve an administrative function that is intended to help ensure the safekeeping of property that police take into their possession and to prevent false claims of loss. Inventory searches are not for officer safety or justified by any sort of concerns related to criminal investigation. That's why no probable cause or even reasonable suspicion is required. But they do have their own set of requirements that must be met for an inventory search to be valid. And these requirements are where you're going to find your potential challenges to inventory searches that might help get you suppression. First, inventory searches can only happen when there is a lawful basis for the police to impound the property at issue, usually a car. Second, the inventory search itself must be done in accordance with departmental policies that are intended to generate an inventory. Finally, and most importantly, inventory searches cannot be used as a ruse for general criminal investigation. And it is the government's burden to establish each of these three requirements in order to show that an inventory search is valid. So let's talk about each of these three requirements in turn and how you might challenge them. First, the lawful basis to impound. This means there must be some law, statute, case law that justifies the police in impounding the car. Second, their decision to impound the car must be in accordance with departmental policy. Departmental policies can give officers some discretion on whether to impound cars under various circumstances. However, the officer's ultimate decision to impound must be reasonable. What kinds of challenges should you consider making to this requirement? Well, consider whether the car was in a location where it could be legally parked and secured. Or perhaps there was another person in the car or that the driver could have called who would have been able to drive the car away for the owner. People versus Siegel, which is cited on this slide, is a great case to help support arguments under either of these circumstances. Basically, was it actually necessary for the police to impound the car? Second, let's talk about the search itself. The search must be in accordance with departmental policy. That policy should direct, and officers in accordance with the policy must actually write up an inventory of the contents of the car. The policy can again give officers some discretion as to what parts of the car to search, but must have officers exercise that discretion based off objective criteria. And finally, a search can include containers or bags or things within a car or the compartments within a car, but only when it is actually expressly permitted by the departmental policy. If the policy is silent, then searching inside containers or compartments within the car would be unreasonable and exceed the scope of the inventory search. As you can imagine, the departmental policy itself is key. You're going to want to get a copy of that policy and review it closely. You're going to note any ways the police failed to comply with the policy, and you may also want to consider whether the policy itself is reasonable and actually serves that administrative function of the inventory search. Some examples of challenges you might make to this second requirement here are, looking at whether or not the government has actually established that there is a policy, whether the officers actually followed the policy. Look at whether there is a tow card. Is there an actual inventory of the contents of the car? And if so, is that inventory complete? If not, you're going to want to challenge the search. And cases like Sweener, as well as the unpublished opinions in DeLue and Matthews noted on this slide, would be great cases to rely on. Let's talk about that third requirement. An inventory search cannot be used as a ruse or a pretext for a general criminal investigation. You're going to want to challenge this requirement if it looks like perhaps the police went beyond what was necessary for an inventory. Perhaps they started dismantling parts of the car And you also are going to want to watch that body-worn camera footage because police actions or their comments, right, might actually show that this inventory search is in fact a pretext and not for this administrative safekeeping purposes that it is supposed to be for. And if so, that can be another basis to challenge the validity of an inventory search. If you would like a one pager with all of this information, including the sites and links to those unpublished opinions, you can use the QR code on your screen right here to download that cheat sheet. This has been another episode of Quick Counsel with Kristen Lavoie and Erin Van Campen. We hope you have found it helpful and that you tune in for our next one. If you would like to check out CLE eligible training videos and more, go to our website at waynecounty defender training.com or use the QR code on your screen.